Good afternoon, everyone. Welcome to today's Notary Town Hall, put on by the Secretary of State's office. Welcome, everybody. Michael Schlein, I'm the Director of the Charities and Legal Services Division at the Secretary of State's office, and we are where you find the Notary Division that you work with on applications and questions and things of that sort. Today's town hall is going to cover the subject of the notary stamping device, i.e. notary seal, journal requirements, formerly known as the Notary's Register of Official Acts, and allowed fees. And we're going to talk about all these in a little more depth and hopefully answer any questions you may have about these subjects, or if you're just tuning in because you're interested in this stuff and just want to hear what we have to say, that's awesome too. And town hall today is going to be recorded. Your participation in the town hall is consent to the recording. This recording will be posted on the notary page of the Secretary of State's website. It's usually posted on there within about a week or so of this town hall. So by usually end of this week, beginning of next week, the recording should be on there. So if something happens and you have to leave, or technological glitches, whatever it is, that recording is going to be there for you to look at any point in time in the future, along with the rest of the recordings from our prior town halls that we've done. They're all there as well, so you can always go back and look at these if there's information you want to hear about that isn't covered in today's town hall and you want to know more about. There are all kinds of town hall recordings there on the notary page that you can take a listen to help in whatever areas those are that you are interested in. There's a chat feature here in Google Meet. You can throw questions in that chat box. I ask that those of you that throw questions in, please refrain from answering other people's questions, though. Very well-intentioned folks sometimes that deliver the wrong information to the people with the questions. Let our notary officers answer that chat box and provide answers to the questions in there. Please refrain from answering other people's questions that they may have, to ensure that we're getting the right answer to those folks. If we don't answer it, we may hold it till later in the end, and it might get read off to me at the end if there's some frequently asked questions about this topic. We tend to read those off at the end, because if multiple people are asking the same thing, we probably want to repeat that or cover that if that's the thing that's happening. Today's town hall is the content and the presentation are provided for informational purposes only. It is not intended to be legal advice. I'm not an attorney, and I'm not anybody's attorney here. So take this for the informational reasons that it is. Trying to convey, again, some specific information about specific topics related to notaries to anybody that wants to join. One other question I get asked sometime is this the same thing as a notary class that I need to renew? No, this is not the notary class that you need to renew. This is not a mandatory thing that you have to attend. This is just our attempt at conducting outreach to notaries and those interested in being notaries or interested in the subject matter, to try to talk about various topics of interest in a little more depth. So it's not the course of study, though, for the purpose of renewing. So again, today's town hall, welcome. Again, being recorded. Recording will be posted online for informational purposes only, not intended to be legal advice. Sources of legal authority. It's in the law, it's in the regulations, and it's in the Maryland Constitution. Notaries public are mentioned in the state's constitution. So just always think that's interesting. It's a very important role that serves a very important function in society today, and very important thing, so much so that's even so not just in the law and the regs, but in the Constitution itself. So pretty interesting. And pretty cool, if you ask me. Notary's official stamp. We're going to cover this topic first, and it is the new law refers to it as a stamping device. and which, folks are very familiar with the term notary seal, is usually the term people really know and think of. But if you see it being referred to as a stamping device, that's why the law calls it a stamping device now. It doesn't call it a seal. That said, it doesn't necessarily have to be a stamp. It's a physical image affixed to or embossed on a tangible record, or an electronic image attached to or logically associated with an electronic record. So effectively, your seal is an image that you are putting on that record when you notarize a document. It could be a stamp, it could be an embosser, and if it's an electronic record for an electronic notarization, it would be an electronic seal, an electronic image that's being attached to that document, to that record that's being notarized. Yeah, it can be an ink stamp, it can be an embosser, so the embosser is the raised marks on the paper. Either way, it works. The notary's official stamp, must be able to be copied together with the record, or is attached or logically associated. When you see that attached or logically associated wording in particular, logically associated is referring to the electronic records that get notarized. Notary stamping device is a public seal for the purposes of this particular section of criminal law. What does that talk about? It talks about public seals and counterfeiting public seals. A notary seal is a public seal. You are a officer of the state of Maryland as a notary public, and your seal is a public seal, and people can't counterfeit it or use it illegally. And you want to take good care of that seal because it does carry a lot of weight. We're going to talk about all that stuff with the seal here shortly. So the notary stamping device, and you're going to hear me use those words, seal or stamping device, kind of interchangeably. Been here a long time, and I still find myself saying seal pretty regularly because that's the term people are most familiar with. But seal or stamping device must contain the following three things: the name of the notary public as it appears on the notary's commission, the words notary public, and the county in which the notary resides or was qualified. And obviously, if it's city of Baltimore, would say Baltimore City or city of Baltimore instead of Baltimore County. Baltimore County and Baltimore City are two different places, two different jurisdictions in the state of Maryland. And most folks know that and understand that, but we do see a share of notary seals that say Baltimore City County or Baltimore County City. That's not a place. Baltimore County is a jurisdiction. Baltimore City is a jurisdiction. They're separate jurisdictions. So if you live in Maryland, you're getting commission in the county in which you reside. And if you work in Maryland, you're going to get commission in a particular county, oftentimes where you work, but not always, depending on the situation. So name as it appears on your commission. Whatever name appears on that commission is the name that should appear on your seal. And that is tremendously important, because if you don't have the right name, I mean, you got to use the name under which you're commissioned. That's the name under which you're allowed to perform acts. If you're using a slightly different name, that's not the name you're commissioned under as a notary. That's not the name you should be using. And that could cause some issues down the road. If it ever came to document being authenticated or something like that, they won't know who, I'm Michael Schlein. If I wanted to be commissioned as Michael Smith Schlein, then that's what name has to appear on my seal. If I'm commissioned as Michael Smith Schlein, then my seal needs to say that. It can't just say Michael Schlein or Michael Smith or what have you. It has to have the name under which I'm commissioned. An important side note to that: when you get an email, when you renew your commission, those of you who have renewed in the last decade or so know that you get an email telling you to go to the clerk of the circuit court and get sworn in. Well, on that email, it has a name, and it's asking you to verify that name. Take a look at that name, read that email. If that name in that email is not correct, you want to reach out to us and tell us so we get the correct name on your commission. So when you get sworn in, you're operating under the right name that you want it to be, that'll match your seal. And effective October 1st, 2020, the notary seal is required to have the notary's expiration date unless the notary's expiration date appears in the notarial certificate. If anybody here has watched, we have one coming up later this year on types of notarial acts and notarial certificates. But if you've looked at the handbook, the notarial certificate always has a place for the notary's expiration date. So as long as your expiration date is in that notarial certificate, it doesn't need to be part of your notary seal. So it only has to be on your seal if it's not in the notarial certificate. A good notarial certificate is going to have a place for your expiration date anyway. So I say that all, that's what the law says, not to create any momentary panic about, oh my goodness, I don't have an expiration date on my notary seal. That's okay as long as your expiration date's in the certificate, the notarial certificate that you have to have on every notarial act these days. Again, we'll have a town hall later this year about just that very subject. And but we have one from last year that covers that topic as well that you can view on our website if you're wondering what I'm talking about when I say notarial certificate. Notary stamping device. The seal is the property and responsibility of the notary public. Even if the notary public had it paid for by somebody else, it's the notary's. You furnish it at your own expense. You buy your own seal, or maybe your company buys it for you if you're doing it because your company wants you to be a notary. But how you pay for your seal is entirely up to you and or your employer. But it's your seal. It has your name on it. Right? Your individual name is on that notary seal. It is yours. Only you can use it. Only you can use it. Coworkers can't use it. Family can't use it. Friends can't use it. Spouse can't use it. Only you can use it. And so that's very important to keep in mind. You're responsible for the security of your stamping device. Never let anybody else use it. If you're employed in one place and you're going to leave that place, be sure to take it with you. I've seen on plenty of occasions where a notary seal was left somewhere and somebody else just started using it. And when something happens, right, when something goes down, who are they going to call first? They're going to call the notary because your name's on that seal. They don't know that you may have left it behind. Don't leave it behind. Don't get yourself in that situation. Take it with you. Even if you leave it on good terms, take it with you. It's your seal. It has your name on it. Don't leave that in the hands of somebody else. And keep it securely. Don't leave it out on your desk for anybody to walk by and use. Keep it in a locked drawer. I know a lot of notaries tell me they got a little baggie that they take their supplies in that they have with them. That's cool. That's great. However, you keep it secure, and don't let anybody else use it. So it must be capable of being copied with the record to which it's affixed. So both a stamping device and an embosser are capable of being copied. You got to do the shading with the embosser to make the image visible, but both are capable and both are used in Maryland and allowed to be used in Maryland as a notary seal. If it's lost or stolen, let us know. As soon as you find out, let us know. If you resign or your commission gets revoked or your commission expires and you decide not to renew, disable that stamping device by destroying, defacing, damaging, erasing, etc. Easy to take apart a stamp, right? You just get the rubber stamper part off of there and cut it up or something like that. A little harder to destroy an embosser seal. But you don't want that to fall into someone else's hands. So whenever you're done being a notary, destroy it, render it unusable. One other thing before I move on to record keeping, people will sometimes ask me, does the stamp have to be circular? Can it be square? Can it be rectangle? Doesn't matter. Doesn't matter. What matters is that it's an image that you can affix to the record and that it has these three things: name, notary public, county in which you're commissioned. So folks will also ask me sometimes, can it say state of Maryland? Sure, as long as it says these three things on it. If you want your seal to say, name, notary public, county, and state of Maryland, great. These three things are the required parts, though. So on to record keeping, notary journal. Required by law, you must maintain a journal. For those that have been notaries for a long time, or prior to the law change in 2020, you also may know this as a fair register of official acts. The journal must chronicle all notarial acts performed by the notary public. Even if you're notarizing for the same people on a regular basis, you got to have a journal entry for every time you notarize. Every time, each and every time. There are no exceptions to that rule. People will say, oh, well, I only notarize for coworkers. Keep a journal. I only notarized for friends. Keep a journal. I know everybody I notarize for. Keep a journal. Always got to have a journal. It's got to chronicle every notarial act you perform. Those entries in the journal shall also be made contemporaneously with the performance of the notarial act. So at the same time in occurrence as the notarial act, you notarize something, you should be making the journal entry. I would even go by the order in a handbook. It's before you even affix the seal, right? Because you have to identify the signer, make sure they are who they say they are. Start making your journal entry then.
What about fingerprinting?
Each and every notarial act have a journal. I'm gonna ask folks to I'll answer that question, but please don't jump in. I'll put those questions in the chat, or at the end we'll save time to raise hands. Fingerprinting is not a requirement of the law. You don't have to have a fingerprint in your journal. I know some journals, they still have them. If you don't know how to fingerprint somebody properly, it's kind of useless anyway. So fingerprints are not a requirement of the law. You don't need to have one in your journal. Unless you actually know how to fingerprint somebody, doesn't mean much anyway. So if the journal shall be retained for 10 years after the performance of the last notarial act chronicled in the journal. 10 years. Got to keep it for 10 years after the performance of the last act in that journal. If your last notarial act in that journal is today, you need to keep it for 10 years from today, which is June 2nd of 2035. Can't believe I'm saying that year out loud. 10 years from the last entry in that journal. Remember when 2025 was a year made in movies about the future. Here we are. So 10 years from the last performance, last act chronicled in that journal. If a notary public's journal is lost or stolen, just like a notary seal, let us know. Let us know it's been lost or stolen. You may not always realize it in the moment that it's happened, but as soon as you realize it, let us know so that we know, so that we can document that. Sometimes notarizations do come back and we have to ask questions about them to you. You want to have the journal because A, you're required by law to have one. No ifs, ands, or buts about that. But B, it's your record of everything you did. And there may be one day where a question is asked about something you did. If you have a good journal entry, you can easily explain who showed up before you, when they showed up, what was notarized, what type of notarial act you performed. We're going to go through requirements of a journal here in a sec. But you have it. It's your historical record of everything you did in your role as an officer of the state of Maryland. Very important to have that journal, not just because the law said so, but you may need it one day to help explain something that you may or may not know anything about, but may get dragged into anyway. Have that journal handy and keep a good journal. We're going to go through the different items required in your journal for each notarial act. And this will sound like a lot. Number one thing that's said to me is, "But Mike, that's so much stuff to write." I mean, maybe, but it takes 60 seconds, 120 seconds. It's not that long in a moment for you to have noted this stuff. And it is worth every bit of seconds should you ever need it in the future. And so each journal entry, separate journal entry for each notarial act. Each journal entry should have the date and time the notarial act was performed. Date and time, according to the law. This isn't the Secretary of State making things up on their own. This is in the law now. A description of the record, if any, and the type of notarial act. Those are two different things. Description of the record, maybe it's a, I don't know, maybe it's adoption paperwork. That's a description of the record. The type of notarial act is acknowledgement, oath, affirmation, official witness, attestation of signature, certified copy. Those are types of acts. So it wants you to list what the record was that you notarized and the type of notarial act you performed. A lot of times we see one or the other. If we ever have to look at a notary journal, we'll see one or the other, but not both. Got to have both. What you notarize, the description of that record is good for you because it helps you remember it. If there should ever be a question, you note it in your book. You know what it even was that you notarized for those people. Type of act, what did I do? Did I administer an acknowledgement or oath or affirmation, or am I just watching somebody signing it and acting as an official witness? The full name and address of each individual for whom the notarial act is performed. Name and address for each individual for whom you're notarizing. If the identity of the individual is based on a personal knowledge, a statement to that effect. So if you use personal knowledge to identify somebody, I know you. Like I know you. I don't just know you in passing or on occasion, but I know you well enough to have personal knowledge of your identity. You would note personal knowledge. Some people will write PK. However, you know personal knowledge. If you identify somebody on satisfactory evidence, whether that's identification credential or credible third-party witness, a brief description of the method of identification used, including the issuance and expiration of any ID that's associated with that identification credential. Most common form of ID, driver's license or non-driver government issued ID card. Or you could have a driver's license from the MVA. You can also, if you don't drive because you don't have a driver's license, you could have a non-driver identification card that the MVA also happens to issue. The most common form of ID is that. Those driver's licenses all have a driver's license number on it. So you would write Maryland driver's MD, MD driver's license. I see a lot of MDDL and then the driver's license number. Issue and expiration date on that driver's license. Passport, right? That's a good ID too. There might be others. We talked a lot about IDs in a prior town hall on identifying signers. If you want to learn more about that, the law and the handbook do a good job of explaining how to identify somebody as well. If you want to read more on that, I don't want to harp too much on the different forms of identification. But talking about it in the most commonly seen ones, what you're going to write in that journal, the fee charged, if any, by the notary. If you don't charge a fee, indicate no fee or $0. Indicate whether an individual making a statement or executing a signature is the subject of a notarial act in your physical presence or remotely. What does that mean? Remote notarizations, a way of doing notarizations while not in the same physical presence with somebody else. but virtually. There's a whole way of doing that. It's a process and has specific technology that you can use to accomplish that. Whole town hall about that one too. That you guys can watch at any point. We'll have another one of those later this year because that's a regularly evolving thing. So that's why it's asking, because you might have been in person, it might have been a remote notarization, and if it's remote, you got to note that. If it's in person, that's most folks are still doing the traditional in-person notarial acts. So all this information, and you know, I get asked a lot of different ways. I'll talk about this with fees too. Everybody always tries to find a way to get more fee. Do I have to have this for every entry in my journal? Yes. Yes. There's no if, and, or but about that. It's required under the law. You got to have these items from these 2 pages, this one here and this one here, for each and every notarial act. Even if you know them, you got to write out a good journal entry. You maybe need to identify them using an identification credential. If you know them personally, you identify them by personal knowledge, but you still got to write out a journal entry of what you're notarizing, when they appeared, what type, date and time they appeared, what you're notarizing, what type of notarial act, how you identified them, what their name and home address is, fee charged, all this stuff here for every journal entry. Different forms of notary journals. You can have a journal on a tangible medium, think paper, book form, or electronic. You can only have one journal, though, for notarization of tangible records. So your traditional notarial acts, one journal. Doesn't matter if it's paper or electronic journal, but one journal to chronicle all those tangible record notarial acts. If you keep a journal on a tangible medium, i.e. paper, that journal must be a permanent bound register with numbered pages. Can't just be loose leaf sheets of paper thrown somewhere. Got to be a permanent bound register with numbered pages. If you're doing electronic notarial acts on electronic records, you could keep one or more journals to chronicle notarial acts performed regarding electronic records. That journal or journals for electronic records must be permanent tamper evident electronic format that complies with the law or any regulations. We don't have a regulation about tamper evident electronic formats, but the law talks about it to some degree. So protect your journal. If it's an electronic journal, make sure your device protects it. You could have a third-party repository. If you have a third-party repository to contain your journal, there should be some type of contract that covers this stuff, that allows you to comply with the retention requirements of act chronicled in that journal, even if the contract is terminated, or provide that the information will be transferred to you if you terminate your contract with a third-party repository. Where in practical terms might this play out with remote notarizations? Your term with them is up, and if they don't allow you to get it when the term is up, they need to transfer it to you when your time with that RON vendor is up. So third-party contract is deemed to be an approved repository of the Secretary of State. We don't have any separately approved repositories, but if you have a contract with a repository for your journal, that is acceptable under the law. Again, that just, you need to be able to get it even after your contract is terminated, or they need to send it to you when your contract is terminated so that you can store it. Same thing with the notary seal. Well, different thing with the notary seal. Seal you want to destroy when you're done. Journal, you got to keep it when you're no longer notary. If you resign or revoked or suspended, keep your journal as required by law. death and adjudication of incompetency. The law even goes into detail now where if a notary were to pass away, the journal goes to their personal representative or guardian or next in line, so to speak, for that individual and their property. So on the charges and fees, talked a lot about stamps and journals. Real quick before we dive into fees, just keep a journal, keep a journal, keep a journal. Trust me when I say, if you ever have to get asked about a notarial act, you want to have that journal. Save you a lot of time and effort. It's not as bad as it seems to do one entry. And, you got to do it anyway. And whatever you do with your journal, same as your notary seal, keep it in your possession. Keep it in your possession. It's yours. You need those records when you go, just like you need your notary seal when you go. If you bounce from place to place, you leave one job, go to the next, take it with you. Take your journal with you, just like you take your seal with you, because that's your journal. That chronicles your notarial acts because you are the individual that's the notary, not a place. You as a person are. So make sure you have that with you when you go somewhere. Folks will say, Mike, I got 3 or 4 old journals. I do a lot of notarial acts. I fill up these journals. Where do I keep them? I don't know. But you got to keep them for 10 years from the last act in it, right? 10 years from the last act in the journal. Keep them somewhere. Put them in a locked file cabinet in your office if you keep them at work, or, put them somewhere at home. Put them in your desk at home if you have a desk at home. But keep them stored somewhere. Keep them stored somewhere. They don't take up a ton of space unless you got a ton of journals. And then they might take up a ton of space, but then you can store them somewhere. So on to notary fees, charges and fees. This page here summarizes what you're allowed to charge as a notary public to perform a notarial act or things related to performing a notarial act. We're going to go over all these things on this page here one by one. And we're going to talk about a scenario. $8 for the performance of an original notarial act. So if you're notarizing for 2 people, that's $8 plus $8. $8 per notarial act. Notice it says up to $8. The law says up to $8. You can demand and receive up to $8. You can't demand more than 8. You also cannot receive more than 8. People will always say, what if they want to give me a tip? Law doesn't allow that. The way all these fees are worded, it's demand and receive up to that amount, not more. You can take less. You don't have to charge at all. But you can't demand and receive more than these amounts for notarial acts. So up to $8 for the performance of an original notarial act. Each signature you're notarizing. You get 3 people, that's $8. If you're notarizing all 3. If you have the same exact document and you're being asked to notarize an additional copy, then it's $4 for each signature on that additional copy. So again, if it's the same document twice, if it's multiple different documents, then it's $8 on each, right? But if it's the same exact documents, $8 per signature on the first and $4 per signature on the second. Notary may not demand and receive more than $2 for each photocopy made of a notarial act. If you're even asked to, you can't make them take a photocopy from you, but if they want a copy of the notarized document made and they ask you to make it for them, you can charge them up to $2 for that. Notary may demand and receive reimbursement for travel at the IRS business travel mileage rate, which right now 70 cents per mile. I believe that has not changed, but always you can check our website. We post it, but always double check the IRS website. Internal Revenue Service mileage rate for business travel. So if you have to drive to do a notary act, you get to charge mileage up to that amount. You also can charge $5 for traveling in addition to the mileage and in addition to the $8 per notarial act. So let's say I'm a notary and I work here in Annapolis. If I drove to wherever, say I drove out to Ellicott City. I always talk about Eastern Shore and Western Maryland. So say Ellicott City, I could charge $5 because I had to go there, plus 70 cents per mile, plus $8 per notarial act. And if I'm doing a remote notarial act, the fee is $30 per remote notarial act. So up to that amount. Demand and receive up to those amounts. There are no tips that you can take. Even if you demand $8, somebody tries to give you more, you're not allowed to receive more than $8 per notarial act. No after hours fees, service fee, convenience fee, everywhere fee. None of that. Number one question I get asked about this slide is, what about, I went to notarize at 11 p.m. I can't charge more for that? Nope, not under the law. You cannot. Can't do that. All right, and these are notary fees. The other second most popular question I get asked in here is, like, I'm a title insurance producer. I'm allowed to charge more to do that. Yeah, that's different than being a notary. That's a different license altogether. You may also notarize when you're acting as a title insurance producer. And for those that aren't sure, title insurance producer is the license in Maryland. People commonly refer to it as a notary signing agent. But the actual term under the law in Maryland is Maryland title insurance producer, which requires you to have a separate license. Whatever fees you charge as a title insurance producer, separate matter than notaries. And if you guys could please make sure you're muted there. I heard hearing some background a little bit. So make sure you understand that concept. Not everybody does. And, we want you to charge the right amount. We don't want you to take less than you have to as a notary. You can take up to these amounts. You don't have to take anything as a notary. But the service you provide as a title insurance producer is different than what you're doing as a notary public. So whatever those fees are, I don't know what typic fees are. I don't know a ton about typic stuff. That's different than what you charge as a notary. And so these are your notary fees that you can charge up to. And so hopefully I made that clear too about, demand and receive up to these amounts. There's no other little tack on fees you can throw on for your work as a notary. These are the fees you can charge. An example of allowable fees. So say a notary public is asked to travel to perform a notarial act on a tangible record. You're traveling 30 miles to perform those duties. When the notary arrives, they must notarize signatures for 2 individuals. So I'm identifying 2 people, looking at their ID, watching them sign a document and maybe complete an oath or an acknowledgement, affirmation, official witness, whatever it is for those 2 individuals. That's $8 per person because I'm notarizing both of them, or for both of them, I should say. I traveled, so I can charge up to $5. And my mileage, I have 30 miles. That's 70 cents a mile. This is what you can charge in that scenario. So in this case, you've got $42 that you could charge because you traveled 30 miles, notarized for 2 individuals, $5 because you left to go somewhere to notarize, plus mileage, plus $8 per notarial act while you were there. In this scenario, that's what you can charge. A good little tip or tool, if you're traveling a lot to notarize, you got to put the fee you charged in your journal, maybe a quick little breakdown of why you charge that fee. Helpful to have should anybody ever ask a question. People do reach out to us when they're being overcharged or where they think they're being overcharged. People reach out to us. And if we get those types of complaints, we'll reach out to the notary about that possible overcharging. So make sure you are, make sure you know why you charge that amount. And it's the law doesn't, it just says the fee charged, but a good tool, you already had to break it down to do the math to charge the total fee anyway, right? So make a quick note of it so you remember in the future why it was that amount. Especially if you're traveling to notarize a lot, you're not going to remember everywhere you ever went or why. So break that down, make note in your journal, a couple extra words, and you're covered on it. So there's some helpful information here. I just want to have some links up there available for Notaries Public. You can go to these pages on our website, and a lot of information. Make our website your landing page for notary stuff. A lot of FAQs, links to all these recordings if you want to watch them later. One of the more frequent questions I get asked is, hey, what's the process to become a notary? I was a notary, I expired, I want to become a notary again. New notary application process link. I'm coming up for renewal. How does that work? Renewal application process link right there off the main notary page. They're one of the first things on our page. Full list of course of study and exam providers. If you're renewing, you only need the course of study, not the exam. Right there, that's the direct link right at the top of our notary page. That first link, the /notaries, /pages, /default.aspx, that's the main notary landing page. If you go to sos.maryland.gov, that's the Secretary of State's homepage, and you'll see the words Notary Public at the top. You click on that, and it takes you to that notary page. That's the main notary landing page. Look at the FAQs, check out this information. Talked to a lot of folks that are notaries over the years, and I've been here coming up on 21 years, involved in notaries in some way, shape, or form for a good chunk of that time, not the entire time, but a good chunk of it. And a lot of folks go, oh, I found it online. It said I can do this. Where'd you find that online? Well, I was in a chat forum. Double check it with us. Notaries in different states sometimes have different things they're allowed to do. Sometimes they can charge different fees or more fees or less fees, or some states require you to have title insurance producer's license to do real estate closing mortgage stuff. Others don't. Maryland does. But double check. What's online isn't always true, and what somebody says isn't always true, and they may be saying it from an entirely different state or location. So always, go to your sources. You have the required course of study when you renew. That information there, that's coming out of the law and the handbook and the regs. But you also have us there as a resource as well. So visit them. We got a lot of frequently asked. There's so many frequently asked questions. I'm wondering how many are frequently asked anymore. There's a lot of frequently asked questions though on our page, on that link on our website, and that covers a lot of different topics. Check them out. And if you have questions, and when in doubt, reach out to us. The last page I'm going to keep up here has our, doesn't have, darn it, our notary information. I'm going to have Carrie, if you don't mind throwing the notary division email address and phone number in the chat box. I'm going to make sure I add that on as the last slide for the next time. 10-974-5520 is the main notary division line. 5520. 5521 is the front desk for the Secretary of State's office. You can get to us that way, but if you just want to ring right into the notary division, 20. And the email address is DL, like division list, the word notary _ SOS, like Secretary of State, at maryland.gov. DL notary _ SOS at maryland.gov. So we'll put that in the chat box here. So I hope this information was helpful to everybody. Carrie Ann, you've been keeping an eye on the chat box. What do you see in there that you think we should chat about now?
Well, we had a couple of really good questions. I'm actually going to jump to the very last question because it goes into what you were just talking about as far as travel expenses. She wants to know if you can charge. In fact, the chat box is blowing up there for the last couple of minutes, and I was trying to stay on top of it.
It always does.
Yeah. So it's Cheryl Parham. Is the mileage calculated on a round trip basis or just one way?
Great question. Round trip. You had to go to and from there to notarize, so you can take the round trip. That's a good question. That's a really
It was
good question.
really good. G. Whittaker said, is shading a raised embossed seal with a pencil or marker acceptable method of making a copyable notarial seal on a document?
Yes. You gotta, if it's an embosser to make the copy, you gotta do the shading. Totally fine. I think most people do the pencil just because it does the job without, I don't know, marker might darken things too much or something. I don't know. But yeah, either way, most customary thing I see is the pencil used to shade to make copies, and that's acceptable.
Okay. And then Pilar Burton, does Maryland require signers to sign your journal?
Good question. It does not. However, it's a really good practice. Really good practice. The law does not require the individual to sign your journal. Most journals you buy will have a place for their signature, though. Get it if you have a space for it. Get it in there. Why do I say that? That's just one more thing to show that they showed up before you. One more thing to show that they knew they were getting something notarized. All is good till it's not in people's worlds. And sometimes when something goes wrong in somebody's life, they might look to undo something that they originally did. Sometimes that has to do with the notarization. Good journals save you from any of that mess. And if you got a spot to put their signature in your journal, get it in your journal. Keep it every time if you can. Said not required under the law, but a great tool to have somebody's signature in your journal. Hard to say they didn't show up to you and know they were getting something notarized by you with their signatures in your journal. Good question.
All right. So Trina Leak wants to know, do I need to keep a journal if I only sworn people in? So I'm going to assume they work at the courthouse.
Reach out to us offline. I don't want to give information that's going to confuse a lot of other people. Court reporter type of work, I'm assuming. Or just general judiciary work. And there's a whole set of Maryland judiciary rules about all that I'm not well versed in, but check in with us offline about that.
Okay. Mike has been a title agent settlement officer. Says he was told that our notary is recorded in land records, which is proof in lieu of a journal. Has this changed? Do I keep a journal for all other notary work?
You keep a journal for all of your notary work, whether it has to do with being a typic or not. Just because it's recorded in land records doesn't make it a journal. That's not a journal. You got to keep your own journal that you are in possession of. That land records recording, I don't know what all is recorded at land records other than the notarized document itself that has to do with real estate. But that's not enough under the way the law is written. It never has been, quite frankly. The law has always required you to keep a journal that's in your possession that has certain things for a certain length of time. Always been the requirement, never not been. The law did change on October 1st, 2020. Big changes in the law that occurred. The law didn't change in that sense. You always had to keep a journal. What changed in the law is all the things that are required in the journal and the length of time for which you must keep it. So the journal's always been a requirement. You've always had to have one. You've always had to make entries in it. You need to do it whether it's related to your typic work or not. If you're a typic and you're doing notarizations as a part of your job as a typic, you should still have a journal entry for your notary work done as a typic.
Okay. And I have one more that I actually got to finish writing down.
All right.
And this one was a pretty good one too, I think. If I'm notarizing multiple documents for one person at one time, so say like separate documents, a POA or something else, can my entry say same as above or such language for the ID info for the repeating info?
Yeah. Some people will put it in one journal entry and they'll say 4 documents, POA, will, whatever other things you might be notarizing. That's fine. The key here is that you're making a journal entry for all those notarial acts and that you know what you notarized. Take the typic example for example, you probably have multiple things being notarized in that packet, and you may have a way of noting exactly what notarizations you performed or what documents you notarized in that entry, and that's okay to do that. That's okay to do that because what you're doing there is you're noting, multiple notarizations, different types of documents. You have a journal entry, same as the above, right? As long as it's the same as the above, that'll do the trick. As long as it says it above, right? We're good with that.
And that's all I got recorded there.
Good question on that too. I agree. Hey, if Carrie Ann's likes your question, it's a good question. You guys get asked a lot of questions every day, notary officers. So even if she didn't say it to you, that doesn't mean it's not. Joking a little bit with
Mike, can I have a question?
Hey, yeah, hang on, man. I'm gonna get there. Hang on. I'll call you guys in order. All right, man. We're gonna finish up our recording here, and then we're just gonna do individual Q&A here for a little bit for anybody that wants to stay on and just chat for a couple minutes. Just thank you all for joining us today again. Again, town hall recording is going to be posted on our website on the notary page, and all the prior recordings are there as well. I'm going to get back to this link page. That link right at the top of this page that you can see right now. That is where we post all of our town hall recordings. Within about a week or so of today, this thing should be up there and posted for you to view at any point in time you need to view it in the future. And, again, informational purposes only, not intended to be legal advice. We got more town halls coming. Take a look at that email we sent out with some future town hall dates on there. We tend to take a little break in the warmer months, in the summer months, when more people tend to be away. So I think this is our last one in the spring. We'll have more coming here in the late summer and the fall. So feel free to join us. And we always, about a week or so before, 5-10 days before the town hall, we'll send out that email invitation with the link for the next town hall and the one after that. Each one has their own link to join. So it won't be this link again. It'll be a fresh link for the next town hall. And so feel free to join us, and hope you got something out of today's town hall. Now, I always tell if you learned anything else from this town hall, if you're not sure, reach out to us and ask. Call us, email us, whatever it is, reach out. We like you to succeed too. We'd rather you ask up front rather than guess and find out later. You got an application pending, it's been in there a while, reach out and ask. Don't let it hang out for weeks and months on end. It doesn't, week or two tops for an application, and then those things are through. That process is way faster than it used to be many years ago to get people reviewed and mostly approved. So reach out and ask. Phone number 410-974-5520 to the main notary division line. DL Notary _SOS@maryland.gov email address. Hope everybody is doing well over there. Thanks again for joining us, and thank you all so much. And this will conclude our recording. And anybody that wants to hang on, give me a minute, and we will stay here and answer some questions on the side. Thank you, guys.